Good morning. The advanced judicial process nowadays being worked is called alternative dispute resolution and particularly arbitration. See, the Arbitration Act and the Arbitration Act as well, Conciliation Act, as two different acts were consolidated, and the Arbitration Conciliation Act was enacted 1996. See, alternative dispute resolution facilitate if you are entering into any contract, whatever may be the contract, if you add a clause that if any dispute arising of either the entire contract or some area of the contract, just like supply of material and standard of materials, that may be referred to arbitrator. That means after serving the pre-litigation notice, if the other party is not complying, then you can straight away appoint, if you have got power to appoint arbitrator, or you can call the other side to appoint arbitrator, or you can file an application under 11 for appointment of arbitrator before the district court or high court if it is within city. And a pending disposal of that main disposal arbitration, interim orders may be sought for and it is being granted. So for that aspect, the question was nemo joda casa. That means one cannot sit and decide his own issues. That was a principle of natural justice out of 3 principles of natural justice. But here Arbitration Conciliation Act empowers the arbitrator to decide his competency, competent to competency, doctrine of competent to competence. In this regard, AIR 2024 Supreme Court 4520, AIR 2024 Supreme Court 4520, this is Cox and Kings Limited versus SAP India Private Limited, another, wherein the area of appointment and the competency of arbitrator to decide the issues. Once arbitration agreement is accepted, so all other things, your objection should be before arbitrator only. That was there. So multi-number of judgments were discussed at various pages of this judgment. AIR 2024 4520, Cox and Kings Limited versus SAP India Limited cases. Then paragraph 14 is important. Then paragraph 24 Supreme Court judgment was discussed. Then they have also discussed about unilateral model law and international commercial arbitration. Then paragraph 26 they have discussed about that. Then paragraph 30 Supreme Court judgment was discussed as well. Paragraph 31 Cox and King Supra. Whatever it may be. Then paragraph 160 it was also discussed. Finally they said whatever your objection, you go to before the arbitration, not come to the court. The power of the courts are very restricted to interfere with arbitration. If the arbitration passes an award, your only way was to file a petition against that order under section 34 of the Arbitration Act. Kindly go through the judgment. Best wishes.